Thank you and welcome to today's session. We continue to cover the labor legal framework in Kenya, and today we look at the Work Injury Benefits Act of 2007. This act is referred to as WIBA, and the purpose of the enactment of this act was to provide a structured, predictable, and non-adversarial system for compensating employees who suffer an injury or die as a result of an accident arising out of and in the course of employment. The law this law starts with a guarantee that if an injury is work-related, then compensation is not optional. It is a legal right. In this law, there is specification for employees or people who are covered. So who is covered by this law? It is provided for in section 3 of the Act, and it says that all employees in Kenya are covered by this law, whether these employees are in public or private sector. The only people who are not covered by this law are the members of the armed forces as a result of the nature of their work. So the law briefly states that if you earn a salary or a wage, then you are covered by WIBA. It applies to you. It applies to both national and county staff, factory workers, drivers, and guards, but not members of the armed forces. So this law also states what counts as a work injury, and this is provided for at section 10. Work injury is defined as injury while working, 1, or injury caused by work, 2, and 3, any disease that one gets as a result of work, what we call occupational disease. So for an injury to count for compensation, the test is very simple. The question is, did work cause it, or did it happen while working? Those are the simplest tests. Did work cause it, or did it happen while working? Those are the simplest tests for this act. So does the worker have to prove the guilt of the employer for them to be compensated? No. Injury as a result of work or in the course of work is not a matter of a court case. The worker does not need to prove that the employer was negligent or careless. So long as it is a work-related injury, then it equals to compensation. Therefore, there is no proof of negligence required. Injury alone is enough, unless the injury was caused as a result of willful misconduct of the employee, which is a rare case. But all work-related injuries don't need any proof. The employee does not need to prove anything. What is the employer's first duty in case of an injury? This is covered by section 7. What does it say? WIBA insurance is not optional. If you have employees, you must insure them. So the first duty of an employer is to insure employees, to make sure that his or her employees have insurance. And that insurance cover must include WIBA liabilities, because if they don't include, in case of an accident, then the employer is liable. So what must be done after an accident? In case there is an injury which has occurred, what must be done? The first thing that must be done is reporting. In case there is a fatal accident, then report within 24 hours. If the accident is non-fatal, then report within 7 days. Where do you report? You report to the Directorate of Occupational Safety and Healthy Services, DOSHS, Directorate of Occupational Safety and Healthy Services. So the main challenge in the compensation of work injuries is delays in reporting. They are the biggest cause of legal trouble under WIBA. So waiting to see what happens is very serious. It makes the law not work. So it is not allowed to report within those specified timelines in case of an injury. Now, what benefits does WIBA provide for any injuries arising from work or caused by work? This is provided for by section 23 to 26. One of the provisions is for medical treatment. An injured worker must be treated. Then if there is temporary disablement payments. Then we have permanent disablement lump sum. And then we have death and dependence benefits. 4 items covered by section 23 to 26. Medical treatment, temporary disablement payments, permanent disablement lump sum, and death and dependence benefits. So WIBA follows the worker from injury to recovery to long-term impact or even death. It covers the worker from injury to recovery to long-term impact or even death. So how is the temporary disablement payment done? This is covered by section 28. Temporary disablement payment, section 28. It is paid if a worker cannot work for 3+ days. If the worker is unable to work for 3+ days, then they get what we call temporary disablement. And what is the payment? The payments equals a worker's earnings. And this payment is done for a maximum of 12 months. So the worker can be paid for a full year if he has been injured. If a worker is injured and stays home recovering, then this law says pay them and stop after 1 year. If a worker stays at home because of an injury, the law says pay them up to 1 year. What about permanent disablement? This is covered by section 30 of the Act. What is the formula? Base compensation for permanent disablement is 96 months earnings. Base compensation, 96 months earnings, multiplied by disability percentage. Subject to statutory mean minor. So the permanent disablement as provided by section 30, there is a specific formula that is used to calculate the payments. The base compensation equals 96 months earnings. So you multiply this by disability percentage, and then you subject it to statutory minimums and maximum pays. So how is it done? For example, if an employee earns Kenya shillings 50,000, so the base will be 50,000 multiplied by 96 months, which gives you 4.8 million. And if disability assessment is at 60%, then the compensation equals to 2.88 million according to the law. So how are these disability percentages given out? We have looked at 60% disability assessment. So disability assessment is done and calculated for by the law. So how is it done? This one is given by the first schedule, where loss of both arms, disability is 100%, percentage is 100%. Loss of one hand, disability percentage is 60%. Loss of 4 fingers, disability is 40%. And total blindness, disability is 100%. While total deafness is 50%. So those percentages are ones which are then used to calculate what we call permanent disablement formula, the formula provided for permanent disablement. And so if the worker dies, what happens? If a worker dies, what happens? This is covered by section 25 and the third schedule, section 25 and the third schedule. So what does it say? If the worker dies, dependents are compensated, and the amount of compensation depends on the number of dependents. Funeral expenses are also payable to that worker who has died. So WIBA protects families, not just workers. Dependents receive compensation based on legally defined percentages. WIBA protects families, not just workers. Dependents receive compensation based on legal defined percentages. And so, what is the time limit for claims? This is provided for by section 26, and that claims must be lodged within 12 months after the death of the worker. So from the date of accident to death, claims must be lodged after 12 months, within 12 months, not after, within 12 months. So who decides the compensation to the employee? This is provided by section 34 to 36, and the Director of Work Injury Benefits investigates claims and makes compensation. The Director of Work Injury Benefits is the one who decides the compensation as provided for by the law. Is supposed to follow the law to provide for compensation. And what are the offenses and penalties for failure to comply with the law? This is provided for by section 52 to 54. Offenses and penalties, section 52 to 54. One of the offenses is failure to insure employees is an offense. Failure to report an accident is an offense. Failure to pay compensation is an offense, and there are fines or imprisonment for those failures. So you must do and the employer has to do to report, to ensure employees to report accidents and to pay compensation without fail. Thank you for listening to me, and I believe that after this session, we want HR actions, supervisor actions, and employee rights to be upheld. Thank you. I'm Dr. Chegene.